think you're going to have to.
Turn it off.
Are you getting any picture there?
Yeah, I am.
Okay. Well, then let me turn this off and remove this.
But I'm not getting it on here.
Not sure we're recording here.
It's recording on the system, but the internet is what I'm having trouble with.
Well, I don't know, it's not showing up here. Well, because this is directly cabled, I think. It's not internet. I'm getting the same picture I had before.
It says it's live. Yeah, I've got a picture now.
You do?
Mm-hmm. But
Okay, what picture do you have?
of you.
Okay.
But it's not, I
Let
don't
me
know
take off the
that.
camera lock. Okay, so that should rotate it. So you are getting a picture?
Here I am, but I'm trying to look to make sure on this one I am. Yep, we're good now.
Okay. And I still don't have a picture here, so
Hmm.
you need to call Tim and find out if
Let me
there's
try
apparently
this.
a problem with my monitor.
Let me check one more thing.
Because it's not showing anything. Ah, there it goes. There it goes.
We were still on presentation mode from Zoom last time.
Oh, okay.
Is it working now?
Yeah. It's not showing up on the whole screen. It's only showing up in the corner, but that's fine. I don't need to see it. All right, sorry about that. All right. Let me start over. You had a charge filed against you in the municipal court, Mr. Reinheimer, that was bound over to the grand jury, and that was a charge of gross sexual imposition of third-degree felony, it appears. Is that the only charge, Mr. Kazim? All right. So that was bound over to the grand jury and was filed with the clerk of this court on July 20th. Now, under Ohio law, no person can be required to come before the court to answer to a felony charge until and unless the grand jury has met and returned an indictment against that individual for that charge. Now, the grand jury is composed of 9 persons who live in this county who are selected to serve as grand jurors for a period of 3 months usually, and they meet at least once a month, more often as needed, to consider cases, evidence submitted to them regarding cases that have allegedly been committed in the county. Crimes, I should say. Now, they then vote after that evidence is presented, and they do not determine whether a person is guilty or innocent, but simply whether or not there's enough evidence to warrant probable cause or a finding that there's enough evidence for the case to go forward and for that person to come before the court to answer to the charge. So therefore, only 7 of those 9 have to vote to indict. Now, if fewer than 7 vote to indict, then there's no indictment. It's called a no bill, and then that person is released from any bond or custody for that particular case. Now, it's not a final decision. It can be resubmitted in the future within the statute of limitations applicable to the charge. But if 7 or more indict, then they file what's called a true bill or a bill of indictment with the court, and then that person comes before the court to enter a plea. And so that has not yet happened in your case. So you're not required to be here today. You're here of your own choice. Is that correct? Okay. And under the law, a person can waive the right to have their case considered by the grand jury and agree to be prosecuted instead by what's called a bill of information. Waive means, in a legal sense, to give up. And so if you agree that you don't need to wait for the grand jury to return a bill of indictment or to consider your case, then you can sign a paper, and I believe you have, and we'll go over those in a minute, that says that you're waiving your right, giving it up, and agreeing to come directly to the court. And then in that case, the bill of information is presented to the court. Now, the bill of information is basically the same as a bill of indictment when an indictment is returned, in that it sets forth what the charge or charges are. However, it's simply signed by the prosecutor or a member of the prosecutor's staff, assistants. And then if a person agrees to be prosecuted in that way, then that basically becomes the charge, and then the case starts. So, you understand your right to have your case considered first by the grand jury. All right, and you're represented by Mr. Perry, and you've talked with him about that, and he's explained that process to you. Okay? Now, I have a document entitled Bill of Information here. Has your case number on it. Titled State of Ohio versus Merle Lee Reinheimer. And it states that, alleges that on or about the period of June 20, 2016, continuing through June 20, 2017, and in Highland County, Ohio, you did engage in sexual conduct with AR, the initials, and that you purposely compelled AR to submit by force or threat of force in violation of Section 2907.02A2 of the Ohio Revised Code, which is a charge of rape, a felony of the first degree. So that's the proposed charge for you to appear today on. Now, I also then have, and it's signed by Mrs. Collins, the prosecuting attorney, I should say. Now, I also have here a waiver of prosecution by indictment. It appears to be a copy because there's a fax header at the top of it. But it's again has your case number and the title of the case, and it's titled Waiver of Prosecution by Indictment, and it says, I, Merle Lee Reinheimer, having been informed by the court of all my constitutional rights, my right to be prosecuted by way of indictment, being represented by Ed Perry, attorney at law, Warren County, Ohio, do hereby freely and voluntarily waive prosecution by indictment and agree to proceed in this manner by bill of information. It was dated September the 9th, 3 weeks ago, and I see what appears to be Mr. Perry's signature there at the bottom with his registration number, and then immediately above that a signature of Merle L. Robinson, and you have a copy of that there in front of you. All right, so am I looking at a copy of the document that you signed? And so you did sign this document and agree to be prosecuted by way of information. Do you have the original, Mr. Perry? Let's, if you don't mind, let's trade so that we have the original signature. Okay, thank you. Now, by signing this, Mr. Reinheimer, then it's indicating that you're agreeing to be prosecuted in this court for the charge of rape in the bill of information rather than waiting for the grand jury. Is that your intention and your intent? Is that what you want to do? Okay. Now, the next step in the process then would be to enter a plea. And typically what happens is that when a person's indicted, they're served with the indictment. If they're in custody, they're brought before the court in custody, or if they're not, they're summoned to appear before the court. And then at that time, they have the option to enter one of two pleas, either guilty or not guilty. Now, a not guilty plea denies any allegations that are contained in the indictment, denies you've committed any crime, and then it means that the case is set for scheduling order, and what that usually means is then that the attorney for the defendant will engage in what's called discovery, which means that they ask for all the evidence and information about the case that's in the possession of the state, witnesses' names and records and reports and statements and any exhibits, photographs, tapes, etc. And then also there's a period of time in which the defense attorney can file a motion that might ask for something such as to suppress, so in other words, to keep out a statement or some piece of evidence that may have been seized. Or there may be other motions that are brought up directed to the case, maybe a dismissal motion or maybe a motion to limit evidence or things of that nature. And so until the person's actually indicted and brought before the court, and the case then begins, because until you're arraigned, it doesn't actually officially begin as far as triggering the process. None of that has happened. Now, since you have retained Mr. Perry, and did you represent him at the municipal court?
I did.
All right. So I assume that you had extensive discussions with him about this matter.
I did.
Okay. Yeah. And Mr. Perry, you had discussions then with the prosecutor's office and had ability to inspect the information that they have available to them?
All right.
So, Mr. Reinheimer, my question is if you're satisfied with the investigation that your attorney has done and that's been shared with you and discussed with you, and your knowledge of the circumstances of the case to the point that you don't feel you need to have that done, that you're ready to go forward today with a plea of guilty? Okay. All right. So, I explained what a not guilty plea is. It denies the allegations and exercises various constitutional rights, which I'll explain to you in a moment. Now, a plea of a guilty is the opposite. It denies the allegation in the indictment. A guilty plea will admit the allegations and give up certain constitutional rights. Now, there's a third plea that might be available, which is called a plea of no contest. In felony cases, that is subject to leave of the court, and the usual reasons for that are usually something involving potentially civil litigation or civil liability issues, or to preserve the right to file an appeal. But that has to be done with leave of the court. So, what we have here today is a plea of guilty form that's been presented to me. And this is a, let's see, 3-page form? Yes, this is actually 4. It's been prepared by the prosecutor's office, and this looks like a fax copy as well. You have the original signed copy there, Mr. Perry. Here, I can just, is that the signed paperwork? Okay.
Judge, did you want a copy without the facts on top one for your signature dates?
Yeah, I'll give it, we can make you a copy, and I'll just put this one here with it, so. All right, so, yeah, if you've got the whole document, we can just swap out. Okay, I have that.
You have that?
All right. Okay, so we'll just, after the hearing, we'll make you a copy of this as well and attach, just so that, for the record, there's two the one that's presented to me, which has the fax header, has Mr. King's original signature, and then the other copy that Mr. Perry just provided me has his and Mr. Reinheimer's signatures. All right. So, Mr. Reinheimer, the form has been prepared by the prosecutor's office from a computer template, which they input the information that's relevant to your case and then print it out. And as I indicated on page 3, and we actually have 2 page 3s here because of different signatures, which is not unusual in legal documents. Down at near the bottom, the last sentence says, "I enter this plea voluntarily," and then right below that there is a signature line with signature defendant printed underneath that, and I can read your signature, and it says Merle L. Reinheimer, and this is your signature I'm looking at? All right. And when did you sign this document, Mr. Reinheimer? If you recall. And maybe Mr. Perry can help you. I'm sorry? Okay. And at that time you had your bill of information, so you had it more than 24 hours. Okay. Now, you were with Mr. Perry when you signed this document? And did he go over it with you and explain it to you and answer any questions you had? And you read it through completely? Now, when you signed it, did you understand that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing? And do you feel that you had enough time to fully consider this matter before making that decision? And since you've signed it, do you still feel that this is the thing you want to do and to go forward with it today? Okay. You feel that you've been pressured or rushed in any way into doing this? Are you entering into the agreement that you've signed and want the court to allow to go forward voluntarily? Okay. All right. Now, the agreement states on page 1 that you're going to enter a plea of guilty to the charge of rape under 2907.02A2, a first-degree felony. Now, that's not the charge we're bound over on, but when the case is bound over the grand jury, or even if it's not bound over the grand jury can meet and whatever evidence is presented, if it justifies a charge, they can return an indictment on that charge, regardless of whether it's been bound over to them or not. So what I'm going to guess happened is that the state may have intended to seek other charges, and that's why you're here today. There's a negotiation. Have I got the gist of that pretty correct, Mr. Perry?
I think you do.
Okay, all right. So that's why the charge is different than what was bound over. Okay? Now, that charge is under 2907.02A2, a first-degree felony. And it further states that you understand that the maximum penalties for that are prison of 11 years maximum. Minimum would be 3 years if a prison term is imposed. There's a maximum fine available of up to $20,000. And prison is mandatory in this particular charge. You understand that? Now, there's what's called a collateral consequence to this. That's not a criminal penalty, but it is a requirement that, well, I guess now it is considered a criminal penalty, and that's why it has to be explained. And that is that conviction of this offense carries a mandatory designation as a Tier 3 sex offender, child victim offender register, which means that you would be required to register for your lifetime as a sex offender with the Sheriff's Department. And if you plead guilty, I'll explain what all that means, but essentially it's a lifetime registration with requirement to verify every 180 days, and then there's some other things that would apply. You're aware of those? Okay. And I'll say just for the record, I do have the form here, but it's not signed yet. Have you seen this form yet, Mr. Perry?
I have it. We reviewed it together.
Okay, all right. Absolutely, that's what I want to, yeah. So, and I just want to make sure for the record that explaining the collateral consequences, that you're aware of what those are going to be.
Yes.
Okay. All right. Are you facing any felony charges in any other jurisdiction? Are you currently on probation, community control, parole, or post-release control for a felony from any other jurisdiction? Now, as I explained to you a moment ago, there's a potential sentence that can be imposed by the court for this offense of between 3 and 11 years. Whatever sentence is imposed is mandatory, meaning it has to be served. There can be no early release or for any reason. You have to serve it all. Under the law, under what's called the Reagan-Tokes law, that is a minimum sentence. Now, the reason I say that is because once you've served whatever term is set by the court, the Department of Rehabilitation and Corrections can decide that you should be kept for a longer period of time, up to 50% of the sentence that was ordered by the judge. So, to illustrate, if I were to sentence you to 10 years, then once you serve the 10 years, the Department of Corrections could determine, and I can't tell you how they're doing that. I mean, I assume they look at a person's record and how they've done in prison and reports and so forth. But again, I have nothing to do with that, so I can't tell you how it works. All I know is they have the right to decide that you should stay in prison for an additional period beyond that set by the judge of up to half of the prison term. So if I give you a 10-year sentence, it could be 15. If I gave you the 3-year sentence, it could be 4.5. A maximum is 11 years that I can impose, and if I do that, that means that they could keep you an additional 5.5 years, so that the sentence could range anywhere as a minimum from 3 years to 16.5 years, because 3 years would be the minimum I could impose, and they gave you 0 additional time. 11 is the maximum I could impose, and they could give you 5.5. So that's the range of the penalty that could be involved for a prison term for this offense. Do you understand that?
Judge,
Yes.
My understanding is the court of the institution that have imposed any additional penalty is conduct while in the institution has been so egregious as other ratings and other corrections officials at business to serious allowing or something along those lines. I just want to know that in the future, you can't exercise the increase in penalty just because they're not.
Well, I don't know whether that's correct or not, Mr. Curry, because I was under the impression that it was designed to keep people that they determined were dangerous to the public in longer. And so, because Reagan Totes was a victim of someone who was paroled and was out like just a few days and murdered. So, I don't know that. I just, for the record, I just want to say this. The Department of Corrections will make its decision, and who knows what they'll base it on when your term's up. It may be something today they would decide based on different criteria, because they could decide to change that. So, and again, and there are some legal challenges to that too that might have a bearing on that in the future. But in any event, you know, I just think the safest thing to tell you is that, you know, that's your attorney's belief. I believe it's more than that. But the bottom line is neither of us know, because we're not, you know, in the department, and we don't make those decisions. They do, and so, you know, we don't know. You'll be up to the. But they are governed by certain requirements of the law that they do have to evaluate to make a reasonable determination. They just can't say, oh, we don't like him, keep him 5.5 years. We like him, let him out, or her. They can't do it that way. So suffice to say that, you know, you won't know until they make the decision, and they'll explain it to you and why they're doing it, if they do. You all right with that, Mr. Perry?
Yes, sir.
Okay. All right. You understand, Ms. Reinheimer? Okay. All righty. Now, once you've served the prison term imposed by the court and any additional time that might be required by the Department of Corrections, if any, you will be required to be under post-release control supervision for a period of 5 years. That's mandatory, and it's 5 full years, because all sex offenses are required to be under supervision once they complete their prison term for 5 years. And that means you'll be supervised by a parole officer on the term set by the Adult Parole Authority. The judge has no involvement in that. And if the department determines that you have failed to comply, and again, they have certain procedures they have to follow, if they decide and determine that you have failed to comply, they have the right to return you to prison, make you serve an additional period of up to 9 months for each violation, but there is a cap of half of whatever prison term you serve for all violations. But if you commit a new felony while under post-release control supervision, then in addition to whatever sentence a judge in the new case could impose upon you, that judge will also be authorized to impose an additional penalty, in this case for that, for committing the new crime while under post-release control, in this case, to 1 year, or whatever time's left of that 5 years, whichever's greater. And so if you had 180 days, it would be 1 year. If you had 3.5 years left, it would be 3.5 years. And any sentence that was imposed for that would be served consecutively to the sentence in the new charge, meaning after, so they would be added together. You understand that? As I explained earlier, it is a mandatory prison term for this offense, and so the portion of this agreement that describes community control or probation has been stricken through. So you understand that that's not a possibility. Whatever sentence I give you has to be served. All right. Now, the charge I read to you a minute ago, I'll read it again, alleges that on or about the period of June 20, 2016, continuing through June 20, 2017, in Highland County, Ohio, you'd engage in sexual conduct with a person identified by the initials AR, and the said Merle Lee Reinheimer purposely compelled AR to submit by force or threat of force in violation of the ORC, Section 2907.02A2, rape, a felony of the first degree. So, that's the charge. Like I said, 3 to 11 years, minimum set by the judge, all mandatory, and then possibility of an additional 1/2 added on top of whatever the court sentences you to, plus a possible fine of $20,000 and a required designation as a Tier 3 sex offender register. Now, Mr. Reinheimer, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it? Do you understand the possible penalties for the offense? Okay. Now, have you discussed the nature of that charge, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney? Are you satisfied with his advice and competence in this matter? Are you under the influence of any types of drugs or alcohol at this time? Are you taking any prescription drugs? And what are they for? Well, let me ask you this. Is it for a physical or mental condition? And what is the medication you take? Okay. Do any of those, well, let me ask you this. Are any of the medications you're taking for either your depression, anxiety, or any other physical conditions or illnesses that you may suffer from, are any of those medications affecting your ability today to understand what's going on, to understand these documents, or to listen to me, or to tell me, or to respond to me appropriately? Okay. So if there's anything you don't understand, just tell your attorney, and then he can explain it further to you, or perhaps I can answer a question if he can. Okay? All right. Now, has anyone threatened you to make you plead guilty here today? Now, on page 2, or page 3, actually, this says, when actually it appears page 4 on the header, but that's because I'm assuming there was a title page in front. But it's actually page 3 of the agreement. There are 2 sentences that are printed in bold and underlined. And they read as follows. Defendant shall enter a plea of guilty to the bill of information. State defense jointly recommend 10 years incarceration. Defendant shall be a Tier 3 registered sex offender. Now, is that your understanding of the agreement? Has anyone promised you anything other than that to get you to plead guilty here today? Now, under the law, the recommendation as a sentencing is not binding on the judge. And so if you plead guilty, I don't have to follow that recommendation. I could give you 11 years or less if I thought it was the right thing to do. You understand that? Okay. And then for the record, Mr. King, the victim, and an adult custodian or parent have been consulted about this in agreement to the... And I see a young lady and what appears to be a parent, perhaps, in the courtroom. Is that the victim and her mother? All right, so they are present for the hearing. All right, very good. So we've complied with the Marcy's law then. All right, thank you. Now, Mr. Reinheimer, do you hold any license or certificate from any state agency for any occupation or profession? Now, you have certain constitutional rights that you must understand before I can accept your plea of guilty. And so I will explain those to you at this point. Now, first of all, you do have a right to have counsel, and you've employed Mr. Perry to represent you. Now, under the law, if you did not have the funds to pay an attorney to continue to represent you, then the court would appoint an attorney for you, and you would not have to pay for that attorney. And so I always ask this question, and that is, you're not entering into this agreement to plead guilty because you're worried about being able to afford to pay an attorney to defend you and what's going to cost you and your family. All right, thank you. Now, you have a right under the law to have a jury trial in this matter, in which 12 people who reside in this county would be selected from a group of Highland County citizens that are summoned for jury duty on your trial date. 12 would be selected from that group, and then the evidence would be presented, and they'd be instructed on the law. And then those 12 jurors would have to decide by unanimous verdict, meaning all of them would have to agree, on whether the state proves your guilt of the charge. Now, if you decided you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, and again, waive means to give up, the right to have a jury trial, and in that case, you would then have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that? Now, under the Constitution, Mr. Reinheimer, you have a right to confront witnesses against you and to cross-examine them through your attorney. So what that means is that if you had a trial, all of the witnesses against you would have to come into the courtroom and testify in front of you and your attorney, the jury, and anyone else that might be present. After the prosecutor was done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that? Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena. And that forces those people that you've named in the subpoena to come to court to testify if you want them to, even though they don't want to be here. which is the same way the state's witnesses are required to come in to testify against you. Do you understand that? Now, under the Constitution, Mr. Reinheimer, you have a privilege against self-incrimination. So what that means is that you cannot be forced to testify or to give evidence against yourself in this proceeding at any time, including the trial. So no one can ever make you testify. The prosecutor can't make you testify. The judge can't make you testify. It's your decision. And if you decide not to testify, the fact that you did not testify in the case cannot be considered or used against you in any way by any person. In fact, no one's even allowed to mention it at any time except in one situation. And that is, if there's a jury trial and you do not testify, then the judge does instruct the jury that because that is your constitutional right, they are not permitted to consider it for any purpose. Do you understand that? Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that you're not required to try to prove that you're not guilty just because you've been accused of a crime. And in this case, you've been accused of the bill of information. And so you don't have to present any evidence in your defense at trial. You may, but you're not required to. But whether you present evidence in your own defense or not, the burden of proof remains on the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, whether it's in front of a jury or a judge, depending upon which type of trial you'd like to have. And that is the highest burden of proof that's known under the law. Do you understand that? Right now, again, you have a right to enter a plea of not guilty to the charge. And as I explained earlier, not guilty plea denies the allegations in the bill of information, denies you committed any crime, and that would exercise all the rights that I've just described for you. Now, if you plead guilty, that is the opposite. The guilty plea admits the allegations in the bill of information, admits that they're a crime, admits that you committed that crime. And that plea waives or gives up all of the rights that I've just described for you this afternoon, except one, the right to an attorney. You always have a right to have an attorney with you at any time, no matter what the charge. But with that exception, your plea of guilty waives or gives up all of the other rights I've explained to you. So your plea of guilty would waive or give up the right to have a jury or court trial. It would waive or give up the right to confront witnesses in open court, cross-examine them through your attorney. It would waive or give up the right to use the power of this court to call or compel witnesses to come to court to testify for you, just like the state. It would waive or give up your privilege against self-incrimination because you're the one that's saying you're guilty, and that's the one what is used to find you guilty. And it waives or gives up your presumption of innocence because if you say you're guilty, then the state does not have to prove that you're guilty. Plea of guilty also waives or gives up any right to file an appeal that you may have had, which you feel you may have had, up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal, and that would have to be filed within 30 days of your sentencing entry being filed. And finally, a plea of guilty subjects you to being sentenced immediately by the court, and I see in the agreement there's not a request for a pre-sentence investigation, and again, it's a mandatory sentence anyway, and so I would not order one if you plead guilty, and so we would go ahead and proceed with sentencing today. You understand all of that? Okay. All right, now, Mr. Reinheimer, do you have any questions about the charge or the possible penalties or consequences of a conviction for the charge of rape? And again, understand it's a mandatory sentence with no early release set by the judge, and then a possible extension of an additional 50% by the Department of Corrections. And you understand that there's a lifetime registration requirement for being convicted of this offense as a sex offender. Do you have any questions about the plea agreement? Do you understand it? Do you have any questions about the constitutional rights I've explained? Do you understand those? Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today? Do you understand? Now, is there anything you need to discuss with Mr. Perry before we go any further? Do you have any questions about anything that I've explained to you here this afternoon? All right, then, Mr. Reinheimer, is it your decision to go forward and plead guilty to the bill of information charging you with rape, a first-degree felony, in accordance with the terms of this written plea agreement that we've just gone over? Okay, then as to the charge, which alleges that on or about the period of June 20, 2016, continuing through June 20, 2017, in Highland County, Ohio, that you did engage in sexual conduct with AR, and the said Merle Lee Reinheimer purposely compelled her to AR to submit by force or threat of force, in violation of Ohio Revised Code Section 2907.02A2, rape, a felony of the first degree, carrying a possible sentence of between 3 and 11 years of mandatory time as imposed by the judge, with a possibility of an additional 1/2 of that, whatever sentence imposed by the judge, being added by the Department of Corrections, a fine of $20,000, and a requirement to be designated as a Tier 3 child offender, sex offender registrant for life. How do you plead? All right. The court finds that on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The court also finds that he did have a copy of the bill of information at least 24 hours prior to entering this plea here today. The plea is accepted and ordered filed. The defendant is found guilty of the charge of rape in violation of Section 2907.02A2, a first-degree felony, as charged in the bill of information. Now, inasmuch as this is a mandatory sentence, there's not a request for a pre-sentence report, and there's a joint recommendation on sentencing with approval of the victim and her adult. The court is going to go ahead and proceed with sentencing forthwith. All right, Mr. King, anything on behalf of the state? Well, wait a minute. I do need to go through the registration requirement first. Thank you. All right. Because of this conviction, Mr. Reinheimer, you're hereby designated as a Tier 3 sex offender, child victim offender registrant under Ohio Chapter 2950 of the Revised Code. That means that you will be required to register in person with the sheriff of the county in which you establish a residency within 3 days of coming into that county, or if you're temporarily domiciled or staying there for more than 3 days. Now, you're also required to register in person with the sheriff of any county in which you establish a place of education immediately upon going into that county. And so if you're attending college classes or trade school or some kind of job training in another county, you would have to register there. If you are employed in a different county for more than 3 days consecutively, or more than 14 days in any one calendar year, then you are, or 14 days or more, I should say, then you're required to register with the sheriff of that county as well. So under the law, you could be subject to being registered in 3 different counties at the same time: where you live, where you're going to a place of education, and where you are working. Now, if you do any of those things in a different state, move to a different state, work in a different state, or go to a place of education in a different state, then you'll be required to register with the sheriff or other public official that is charged with the duties under the laws of that state for maintaining sex offender registration and monitoring requirements. Now, if you are going to be gone for 7 days or more from your residence, you're visiting family, you're on vacation, you're gone to a hospital, recovery or something of that nature, if you're going to be gone for 7 days or more, then you have to notify the sheriff of the information about where you will be staying temporarily, and your address, the address and then the length of the stay, if you know. Now, you are required to verify your and contact the sheriff every 90 days. I think I might have said earlier 180, but it's every 90 days for Tier 3. And that means you have to go into the sheriff's office in person no earlier than 10 days before that, in person, to verify all of your information that you're required to provide them. And so you can't go on a 11 days before, you can go 10 days before, but no later than every 90 days. Now, if you change your address, place of employment, or place of education, you're to provide written notice of that as well to the sheriffs of the counties in which you're registered or other officials if in another state. Now, you have to give the advance notice of that if you're changing your residence at least 20 days in advance, or your place of education. As far as employment is concerned, you don't have to report that until 3 days after you've been there, because, as I explained to you earlier, you do have a right to be in another location for 3 days to work. But once you go past the 3 days, or if you're there for more than 14 days in a particular year, then you have to register in that county. Should you at any time not have a fixed address, then you will provide a description of the place or places where you intend to stay, and then not later than the end of the first business day, immediately following the day you do obtain a fixed address, you must register with the sheriff that fixed address. You're also required to provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers that are registered to or used by you with the sheriff or sheriffs with whom you have been recently registered. You're further required to, in accordance with federal law, to report any international travel that you intend to do to your registering authority or authorities not later than 21 days prior to that travel. And if you fail to do that, that could subject you to being criminally prosecuted. Now, if you fail to comply with any of these obligations, then you could be subject to being prosecuted under Chapter 2950 for violations, which would be felonies, depending upon what the situation was. That would depend on the seriousness of that. That would subject you to being prosecuted, and if convicted, serving an additional term of incarceration. And the registration address that you would be, since you're currently a resident of this county, registration address for you would be 130 Homestead Avenue, Hillsborough, Ohio 45133 here in Highland County. All right, I'm going to sign, indicating that I have advised you of these requirements. And there's a paragraph 11 there for you to sign, stating that I acknowledge the above requirements been explained to me, and I must abide by all provisions of our revised code, Chapter 2950. And I'll put the date there as the day. And Mr. Perry, the coach can sign that, and then if you would give that to the bailiff, and then she'll get copies for counsel and defendant, and then the original will go to the trial. All right, the record then will reflect that Mr. Reinheimer has signed the form that verifying that he's had his sex offender registration law under Chapter 2950 explained to him. Now, we'll proceed to sentencing. So, Mr. King, on behalf of the state.
Thank you, Your Honor. The state would ask that the court follow the joint recommendation. The victim in this case is the defendant's daughter. She was approximately 10 years of age at the time of the offense. The victim and her mother, Jennifer Reinheimer, are both present in the courtroom today, as I've already indicated. And it's my understanding that Jennifer Reinheimer would like to make a statement if the court would permit.
Absolutely. All right. Jennifer Reinheimer, your AR's mother?
Yes.
All right. You may go ahead and make a statement or read any statement.
All I ever wanted, is to get married and have children. One girl and one boy. Abby came first, she was tiny and precious. Marcus came 4 years later. He was our big boy. Abby was 4 when he was born, and we lived on Hill Road with my family. Mom started watching them when Marcus was about a year old, so I could go back to work. Marcus was 3 when Mom died, and oh, how you cried. That was only the second time I'd ever seen me cry and laugh. Boy, if Mom would have known what you were doing to Abby, and all of us would have known all those years what you were doing to her. She remembered back as far as 5 or 6 when it started. Was it longer? For 2/3 of her life you touched her, had her touch you, and God knows what else for how often. So far, I think she has blocked a lot, which is a defense mechanism for trauma. She has nightmares. She is unable to go to school because of anxiety. She is scared of seeing you or you coming to get her. There was an old man at the bowling alley that stared at her about 3 years ago. I thought that was why her anxieties started up, but it just triggered something that was inside and brought the anxiety to the surface. You caused it. Earlier this year, severe depression started, and we had to take her to a psychiatrist. She takes antidepressant and medicine for anxiety because of you. She sees 2 counselors now, one of which is trained for trauma. I did not know anything was going on until that night when you were forced to tell me because she finally stood up to you. You told me of 2 times that happened, one of which you pretty much blamed her for. That was one too many times for me to make you leave and make sure you could not touch her again. She never said a word to anybody because she was afraid of what would happen to her family. She carried all of us to save her family. She suffered because she didn't want to break us all up. She suffered because of it. Because of you, Abby will have a lifetime of pain and torment for what you have done to her. Because of you, Marcus will have to grow up without a father to teach him how to fix things. He hates you for what you have done, Abby, all because you couldn't keep your disgusting hands to yourself. 10 years is not near long enough for 10 years you took from her because she will have many more years of pain from you. I can say so much more. This mama bear is coming to the end. Think of this. You better start praying now for your soul because you are going to need a lifetime of prayer to be what you have done.
Anything further?
Nothing further, Your Honor.
AR does not wish to make any statement.
That's correct, Your Honor.
All right. Mr. Perry, you have the defendant.
Judge, we would join the prosecution in this case and ask the court to accept and impose the recommended sentence of 10 years. To the extent that he can heal his daughter's wounds, he has accepted responsibility to stand before the court without guilt. Again, we ask the court to impose the recommended sentence.
And Mr. Reinheimer, is there anything you would like to say? Or not sentence? Well, Ms. Reinheimer raised it first year time, raised the trial, and I think my estimation as well as most people's estimation is most despicable crime that a person committed. And your attorney's done an excellent job for you negotiating this plea because, possible charges that could have been returned would have been much more serious. The only positive thing I can say about you is that you pled guilty in order, and because of that, it has avoided your daughter having to go through a trial. Because no matter how strong the evidence is against a person, in any case, particularly in a sex offense, it is a very traumatizing event. Now, I'm not going to say that you did that out of totally out of a motive of avoiding that, because you have gotten, an agreement to lead to a lesser penalty offense. But that is the result, and so I understand why that is done. And, I think it's in the best interest of the child. Now, most people in the public are not going to agree with that. Most people think that he should be executed, get the death penalty. And, as a father and a grandfather, I would agree that's a reasonable outcome. Or if it was one of my children and our grandchildren did wise, but that's not the law. And so, again, that's the only positive thing I can see out of this is that she's not going to have to relive this, because what her mother just described as what she was suffering is certainly consistent with what happens in other cases to other victims. And we don't know how she'll do. We can only hope and pray that her therapist and her the support of her family and love her, that she'll be able to get through this and be able to lead a happy life. So, that being said, I'm going to follow the agreement because if I gave the maximum, then you did file an appeal. It doesn't seem to be any point in that. And so it's the order of judgment of the court that you are hereby sentenced to the Correctional Reception Center, Orion, Ohio, for a period of 10 years. That would be a mandatory sentence, must be every day of which must be served. And according to the sheriff and the record of the file, I believe you didn't go behind bars, you turned yourself in, at least immediately, right? So you have 0 days of jail time credit. Now, that is minimum mandatory and not being reduced by the court in any way. Well, let me back up. The sheriff says you got arrested on the 10th.
Yeah, I've spent 2 nights.
Oh, okay, all right, so they gave you actually credit for 3 days, so there is 3 days of jail time credit. But I was just looking at the file. The warrant was filed on the 14th, we released on the 14th, so that's why I assumed it was. I didn't know we had this document, so we do get 3 days of credit. Now, you will have to serve every day of that, and as I explained to you earlier, based upon whatever guidance and policies that are in place or legal requirements are in place for the Department of Corrections, that they can decide to, under the current law, to extend your sentence for up to 50% of that. So that means they could extend it to 15 years, an additional buffer. But again, we don't know what will happen. That'll be their decision. Now, upon completion of the prison term, you will be required to be under post-release control supervision under terms and conditions set by the Adult Parole Authority for a period of 5 full years. And again, that's up to them. They said that the judge has nothing to do with it. And if they decide you have failed to comply with those conditions, they can return you to prison, make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of the prison term for all violations as a cap. However, if you commit a new felony while under post-release control supervision, then in addition, whenever sentence a judge in the new case is imposed upon you, that judge is also authorized to sentence you for committing that new felony while under post-release control in this case to an additional period of 1 year, whatever time you left on that 5 years of post-release control, whichever case is greater. If that occurs, that would be served consecutively to the sentence in the new case. Also, order to pay the court costs for which judgment and grant execution is ordered. If you fail to do that, then the clerk reports can collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. And if that doesn't collect, then once you're released from prison, the court could order you to community service and give you credit for each hour you worked. And each hour you worked, you reduce your judgment by that amount until paid in full. Now, community service would have to be performed in this county, it cannot be done while you're in prison. All right. Is there anything further from counsel? All right. Mr. Reinheimer, you are remanded to the custody of the sheriff.
Right, Your Honor.
You may. Anything further, Mr. Perry?
Nothing further, Judge.
All right, thank you.